person. And also we have a few virtually as well. So, Madam Clerk, at this time, could you please call the roll?
Senator Alvarado.
Here.
Senator Harper Angel.
Present remotely off campus.
Thank you. Senator McDaniel. Senator McGarvey. Senator Nemes.
Present in the room.
Senator Schroeder. Senator Southworth. Senator Storm.
Present in my district.
Thank you. Senator Thayer.
Here in the room.
Senator Wheeler. Representative Blanton.
Present in the room.
Representative Bowling.
Here in the room.
Representative Cantrell.
I'm here. I'm upstairs in my annex office.
Thank you. Representative Decker.
Present in the room.
Representative Duplessis.
Here remotely.
Thank you. Representative Fisher.
Here in the room.
Representative Flood.
He's gone.
Here in the 75th District.
Thank you. Representative Gooch.
Here in the room.
Representative Graham.
Here.
Representative Heath.
Present from my district in Mayfield.
Thank you. Representative Heverin.
Present in the room.
Representative Imes.
Present in the room.
Representative Johnson.
Present in the room.
Representative Cook.
Here in the room.
Representative Derek Lewis.
Present remotely from the 90th District.
Thank you. Representative Scott Lewis.
Here in the room.
Representative Maddox. Representative Meeks. Representative Mentor.
Present in the room.
Representative Moser. Representative Nemes.
Present in the room.
Representative Scott.
Present in District 41.
Thank you. Representative Smith.
Present in the room.
Representative Stevenson.
Present in the room.
Representative Tate. Representative Tipton.
Present in the room.
Representative Upchurch.
Present in the room.
Representative Weber.
Present in the room.
Representative Wheatley.
Here in the room.
Representative Bratcher.
Here in the room.
Representative Miller. Senator Mills.
I'm here in the room. Thank you, Madam Clerk. We have a quorum and are duly constituted to do our business here today. Thank you again for being here and being in person. I think this large committee, it's good to see everybody's faces again. So, as you all know, that one of the biggest tasks that this committee has before it in the next year is redistricting. And we wanted to start off the interim season just to get kind of a 10,000-foot view of the legal environment surrounding redistricting. And who better to give that to us than some experts, national experts from NCSL. So we have virtually, we have Wendy Underhill, who is the Director of Elections and Redistricting for NCSL. And we also have Ben Williams, who's a policy specialist for elections and redistricting for NCSL. So we have dedicated our whole meeting to hearing their presentation, and then we'll have time to ask questions at the end. So Mr. Williams or Mrs. Underhill, the program is yours, and please feel free to move forward. Thank you.
Thank you, Chairman Mills and members of the committee. It's our pleasure to be with you. I just wish that we were actually with you. We had some thoughts about that and last minute decided to stay back in Denver. I am indeed Wendy Underhill. I'm the Director of Elections and Redistricting at the National Conference of State Legislatures. And Ben Williams, who you'll hear from second, and I work on redistricting and the census. Just so you know, NCSL is the nation's bipartisan organization, and the reason we exist is to serve the needs of legislators and legislative staff throughout the states and territories. Let's go to the next slide. Our structure is bipartisan. That means our leadership at the tippy top goes DRDR. Our work, however, I would say is nonpartisan. The work that we produce, we like to imagine can be read and appreciated by people of either political party or outside. It's just data is mostly what we do. And you can see some other things that we do here on this slide. But from my perspective, the bread and butter issue that we do is respond to research requests from you all. We handle these in a confidential manner. That means we don't share with other people in your state or from other states what we're being asked about. So if any of you would like to contact Ben or me after the hearing, please feel free. That's what we get paid to do. And then I guess the last caveat is that NCSL does not offer advice on policy matters that come before state legislatures. We do have a role in DC where our staff lobbies Congress for states' rights, but when an issue is in front of a legislature, we are there to provide a 50-state perspective. So we've divided our work into two sections today. First, the census, and second, redistricting. And in other decades, it wouldn't have been necessary to have a chunk about the census. The census was just assumed. You turn on the tap and water comes out, you go to the census and data comes out. But that has not been true this decade. So we're going to spend a little bit of time on that. And then I will turn it over to Ben for the redistricting side of things. And we are happy to take questions in the middle if that makes sense, but I'll just go forward and we'll ask that question when I get done with this first chunk. So the census really does matter, and it matters because every year for the last 10 years, $1.5 trillion in federal funding has been distributed across the states based on formulas that use census data. And it's good to start with the money aspect. I know that we're here to talk about redistricting, and that matters a huge amount for that too, but I will just say states have a lot at stake because of the amount of federal funding that comes in. And that is $15.8 billion is estimated to come to Kentucky every year based on the previous census. That's a big chunk of money. Apportionment is determined, of course, by the census. Redistricting can't be done to meet the one person, one vote principle without good data. And also the census is used by policymakers at all levels of government and outside of government to make the decisions they need to do. I like to think of Walmart knows where to put its next store based on census data. So there are two releases of data from the census that come in the year following the census itself. And the first of those has already arrived. That's the apportionment data, and it came on April 26th. And the second data release, the one that's more important, is still yet to come. So what we know now is how many people live in each state. We don't know anything about them, but we know how many people live in each state. And we know then how that translates to congressional seats. And we know what the growth trends are. And it won't be any surprise to know that the Northeast and the Midwest are losing out, proportionally speaking, to the South and to the West. Back up just a second, Ben, for the other side. Then in terms of the second data release, that will tell us the details about where within a state population has shifted and what the nature of the state is demographically. So race will be available then. And this data is expected by August 16th. But I do want to stop for a moment and talk about August 16th versus September 30th. The Census Bureau had originally said, well, originally this data was all to be out by April 1st. But because of delays, which we'll talk a little bit about, the Census Bureau had said that it would release this detailed data on September 30th. And then a few months later, it said, well, actually, we can give it to you on August 16th in a different format than what we'll give it to you on September 30th. So it is the same data. The numbers will not change from the one date to the other. But this is still a little bit of a hiccup for states because it's not clear in all states whether that August 16th release can be considered the official release from the Census Bureau. And our expectation is that different states will interpret that differently. But the data will be the exact same, whether you start on August 16th or you wait until September 30th. What will be different is that on August 16th, your data meisters will go into a portal at the Census Bureau and extract what they need. Whereas on September 30th, the Census Bureau will send DVDs and flash drives to the states with the data in a more easily interpretable fashion for your everyday person on the street. Your data people should have no problem with the August 16th data. It's just us everyday folk who might have an easier time reading what's handed out in September. All right, now we can go to the next slide then. So it's no surprise that Kentucky neither lost nor gained a seat in Congress, but I still thought it might be fun to see who did lose and gain. The green states gained, the peach states lost. Texas was the only state that gained 2, and no states lost 2. And then we can just go over a few of the highlights of the census. And the first is that the nation grew by 7.4% in between the 2010 and the 2020 censuses. And that is the lowest growth rate since the 1930s. And then all but 3 states did see a population increase. Of course, some grew faster than others, which we'll see on another slide. 3 states did lose population, and that in particular, I'll call out West Virginia, which lost over 3% of its population, which is a really remarkable loss for your neighbors. Next slide. So Kentucky grew at 3.7%. And I'm pretty sure that you all will understand way better than I will where that growth took place or anything about what that means for you. There were states that were very high, over 15% growth. And then, as I said, there were the states that had the decrease, just those 3 states. And in terms of details for Kentucky specifically, your May primary is the 8th in the nation. So that means it's fairly early in the primary season. You're not alone in being that early. It seems to me that your constitution provides less of a pinch as to when your redistricting has to be done relative to some of the other states who have earlier deadlines. And Kentucky is one of 17 states where the Constitution doesn't explicitly say that you must use the decennial census data for redistricting. By me calling that out, I'm not in any way suggesting you should do anything other than use the decennial census data. Just a sort of fun fact to know that a lot of states are explicit that they say when the decennial census data arrives, da 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 da. And then I'll offer that just in terms of the way the census operates, no 2 have ever been the same. Technology, of course, has changed. It used to be done by U.S. Marshals on horseback. Here we've got a picture, I believe that's in 1920, gathering information on a clipboard. And 1920 was an interesting year in that there was no reapportionment for Congress done that year. They just couldn't get it done. So they used the same seats from 1910 all the way up to 1930. And then 1960 was the first time that forms were mailed out to people. But even then, people went around and picked up the completed forms. And then in 1975, Public Law 94-171 was passed by Congress. And it had a great deal of support from NCSL and the states. It's sort of almost part of the origin story for NCSL that the states came together to say to Congress, if we're going to have to redistrict every decade, we need good data to do it. And so this data is now required to be produced by the Census Bureau in a format that is quite granular for specifically the needs of redistricting. And that's the data we're waiting for until August or September, depending on how you look at it. And this decade in particular is different because of those delays and the fact that there's sort of these 2 releases of the same data, and also how people were counted. So let's look at the next slide for that then. This was the first year where there was an online option for completing your questionnaire. And I'm guessing that many of the people in the room here did use that online option. Turned out to be more successful than the Census Bureau had anticipated. But it was still completely fine to respond by mail. If you didn't respond online or in some other way, then the full questionnaire was mailed out to your household. So, and then there were some people who got the full form anyway without having to ask for it. And this was a year when they could call in by phone. And that was, the phone number was distributed by postcards to people around the nation. And there were people who could answer your call in 12 languages plus English on the phone. And then they also supported this in 59 other languages through video guides and such things. And then there is still the door knocking operation. They are called the enumerators, and they're not volunteers, they're paid, but it's a large but short term workforce. It's about 500,000 people get hired to go knock on doors and make sure that everybody has done what they needed to do. And my husband, who's mostly retired, chose to do that. So we had interesting stories in our household from his times out in the street trying to track people down, and my conversations with legislators and the Census Bureau about how things were going. those field operations were particularly hard hit by the pandemic. And I say that because they were to start in March, which was, of course, when the pandemic started. So everything was shut down for a while, and then it was all delayed. And then the last method for counting people was imputation. And this has been true in previous decades as well. But if a household didn't respond with by paper, by a knock at the door, by going online, but yet the Census Bureau knew that there was a house there or household, whatever that might look like, then the enumerators could actually ask the mail carrier or a neighbor, like, who lives in this house? Can you help me fill it in? And if that wasn't available, then administrative records were often available. So utility bills and tax records, that kind of thing. So there's some amount of filling in the details based on imputation instead of actual direct responses from householders themselves. So I keep talking about these delays. And of course, everything last year was delayed. It was an unprecedented year in every possible way. We've talked about the pandemic. There were fires, floods, and tornadoes that slowed down in the enumeration process in several states. Texas comes to mind in particular. There were policy changes during that enumeration time. There were some lawsuits that sort of go this way, no, go that way. So that was kind of a problem. And then there was the decision to use a new system for avoiding the release of private information. It's called Differential Privacy. That just took a little bit of, it is potentially contributing to the delays that we're now seeing. But whatever the facts about the background, what we know is that the data is arriving either 4.5 months late or 6 months late, depending on whether you use that August date. So what are the problems with having delays? Before I actually get to problems with delays, I just will say that no matter when it arrived, the people in each state that manage the data, and those could be legislative staff or they could be the software vendor staff, they need a couple of weeks at least to prep the data. My point is that when it arrives on August 16th, you can't start drawing lines on August 17th. You have to let these folks do a little bit of work to make sure that the data is imported properly into your software and do some dry runs with it. So there is a processing delay yet to come. And then after that, there's a whole lot more that happens in addition to redistricting. There are these deadlines, and I see that Kentucky has a November 3rd candidate filing deadline. So that would mean to me that you'd want these maps fully up and ready to go before you got to the start of that filing period. Then in some states, there's a residency requirement. If a person has to live in the state for a whole year before they can run, that might easily mean that there's a November deadline. You've got it through the opening of your candidate filing deadline. And then after the maps are drawn, they still get handed off to local election officials who have a great deal of work to do. And this would be a place where understanding how it works specifically in Kentucky could be useful. But in general, those folks are making sure that each voter is assigned to the exact right district, whether it's the congressional district or right down to a local district. And they're also probably redrawing the precincts. And it's so that the precincts fit within the maps that you all could hand off to them. And then, of course, there's the primaries themselves. So a lot of action that's dependent on this timeline of redistricting. I will say, and that's fine, Ben, that there is a little bit of a silver lining with this delays, and that is that the Bureau does have more time to work on its data quality stuff, so maybe that's good. And it is possible for your state, if you choose to maybe draw some preliminary maps with other data, like your state demographer probably knows where growth is taking place, and therefore districts would get geographically smaller so that you would keep the same number of people in each. So if that helps you at all to do some preliminary maps, that's possible. And then also this time period before the data lands is an opportunity to find out what the public's interests are and do public hearings, that kind of thing, about what do they think are their communities of interest. Okay, so on the slide we've got now, Kentucky fits in the largest circle over there on the right. I think you could count yourselves as lucky that you don't have a deadline for, say, June 30th, which is the deadline that Illinois was working with to create its maps. And so, in fact, I think it's not so much your constitutional deadlines as it is your filing, the opening of your filing date that matters. All right, and Ben, I think we can skip that one and I'll just work off of the next slide. Yeah. So how are states addressing these delays? There are a number of states that really aren't going to do much. And I think that that's a place where probably you are, other than maybe you'll do your public hearings. That would be a thing that you could be doing now. But in some states that have those harder deadlines, you can go to the courts and ask for relief. And we have 3 states that have done that. If the Constitution says you have to have the data done by June 30th, that's pretty much impossible if the data hasn't arrived. So those states have asked preemptively for relief. You could also change the legal deadline, move it outward, whether for this decade or for all decades yet to come. You could alter election dates. North Carolina actually moved its spring local elections, and it runs them in the springtime. They are the municipal ones, but they just said, well, we're going to just do that later so that we get a chance to complete redistricting and complete re-precincting, and then we'll be ready for that. Wisconsin might do the same thing. And then there's a process that Ben called the two-step. Oklahoma chose to do this. I'm not sure if he was thinking of Oklahoma as he was thinking of two-step dance or not, but perhaps. What they did was they chose to use, they had one of those early deadlines. So they used American Community Survey data, which comes from the Census Bureau, but is not one and the same as the decennial census data. The ACS data, it looks over 5 years and makes estimate of the data based on a 5-year survey. And then they adopted their legislative maps with that. And now Illinois has done the same thing as well. So Arkansas and Indiana have extended their official session 2021 session because they're supposed to do their redistricting during that session. So instead of gaveling out, they're just going to keep it open until they get to it. And then some states are looking at special sessions. And I'm guessing that you might be thinking about that as well. That and I look forward to hearing more about whether that's exactly right or not. Then I've got just 2 more slides for you about the census. One is about census quality. And there are a whole lot of pieces that go into quality. The one I want to mention is that there are people who think that there was an undercount this year because they were trying to count people during the pandemic. There was certainly a question about where students were being counted. Were they counted at the university or were they counted at their house? Were they counted twice or were they missed altogether? So that's a data quality question yet to come. And then there's this other one about this system being used by the Census Bureau this time to protect private information. And that's causing a push-pull, I guess you'd say, between data accuracy and usability. And in fact, that leads us to the lawsuits that we're already seeing this year. It's not the least bit uncommon for the Census Bureau to be sued. And it's been sued twice already in 2021 about the delays. The Ohio case was just specifically about the delays, and it's in the rearview mirror at this point. In Alabama, though, a case is still in front of a 3-judge federal court. And any day now, I was actually hoping we would have the information to share with you. We'll get an answer about it. The reason it matters to Kentucky, what goes on in Alabama, is that the case is was brought forward because not just the delays, but because of the question about the accuracy of the data that the Census Bureau will be able to produce because of its system for protecting privacy this year, which is different than it's used in previous years. If the plaintiffs do prevail, then we will all be into a whole lot more uncertainty because the Bureau has said that if they can't use that system it's elected to use, it will take several more months for them to process the data in a different way to be able to get it out to the states. So that's just a lot of uncertainty yet to come. Although maybe it'll be determined, literally, we look at the court docket every day and see if there's any news on that front. And then in Illinois, I mentioned earlier that they chose to use the American Community Survey data, and they have been sued by 2 different groups over their choice to do that. So we will see whether that alternative data set is appropriate for Illinois' state courts where redistricting there. So that's what I brought about the census. And I'm now either happy to take questions, Mr. Chair, if you'd like us to. I know we said we were going to hold them to the end, here's a breaking point, up to you, or we can just go straight on to Ben.
Yes, thank you so much. I do think this is a good time to take questions. Senator Thayer has one thing to add, maybe a correction.
Thank you, Mr. Chairman. Thank you, Wendy, for that excellent overview. I just want to make one correction. Our filing deadline is the first Friday after the first Tuesday. You probably saw that that November date is when candidates may begin filing. So that would be the confusion there. But while we're on that topic, Mr. Chairman, I want to point out that if we want to get this right for the constituents who we represent, and we want to stay in conformity with the spirit and letter of the 14th Amendment to the Constitution, which is one person, one vote, we're going to need a special session during the fourth quarter of this year. Because if we don't, and we've already, and I'll do it again today, we've already started to inform Governor Beshear that we're going to need a special session because of the delays in the census data due to COVID. We're going to have to come in January, on January 4th, and we're going to have to move the filing deadline. Now, remember, recently we moved the filing deadline up from late in January to early January. And we all know the reason we did that. Under previous party control of the House of Representatives, there was a lack of interest in passing bills during January until the filing deadline occurred and people knew who their opponents were or if they were going to have an opponent, et cetera. But I'd like to note that once Republicans took over the House, we passed with alacrity the filing deadline moving up to early January. So we have no excuse not to get to work right away and start passing bills. But if we don't have a special session, and I'll repeat, we are going to have to come in and pass a new bill that temporarily, i.e. for 1 year, moves the filing deadline back to probably late January or perhaps into February. Because we're then going to have to pass the new maps. And we have 3 maps to pass: congressional districts, House districts, and Senate districts. And you know, one would think we could be ready to go with agreed upon maps by the 1st of January, but it's still going to take a little time. And then you've got to pass the maps, wait and see if the governor signs or vetoes them. If he vetoes them, then we're going to have to take the time to override the veto. And then you're going to have to give people a few weeks at least to digest the new districts, to figure out what district they live in. There's going to be some changes. Everybody needs to understand we have, again, we don't have the county or precinct level data yet, but we know from census trends and estimates that there is a huge population shift occurring in this Commonwealth. People are moving out of eastern Kentucky and out of western Kentucky, and they're moving generally into the Golden Triangle, Lexington, Louisville, northern Kentucky, but also more generally speaking, between the interstates. Also, Bowling Green has seen growth, and Owensboro has seen growth. That's the one place outside of, in between I-65 and I-75 that we're seeing growth. So we're going to have some really tough decisions to make. These maps in eastern and western Kentucky are going to look differently. There are going to be fewer districts, fewer Senate districts and fewer House districts in eastern and western Kentucky. So we might as well get that out there and on the record as early as possible. And we're here in June, and that's about as early as we can, Mr. Chairman. And I appreciate you putting this on the topic right out of the starting gate in the interim. So keep that in mind. Candidates, which would be all of our congressional districts, all of our House districts, and the even-numbered Senate districts, can begin filing for office in early November. But we're not going to know the districts then unless the governor calls us into a special session. So once we get these data dumps from the U.S. Census Bureau and we know the precincts and we know the county population, then each chamber can begin working on its map and we can also start working on a congressional map. A couple other things that new members may want to know. As I look around this room, there actually aren't very many members here who were here for the last redistricting. Representative Graham, Representative Fisher, Representative Weber, Representative Gooch. Yeah, Representative Upchurch. That's it as far as those in the room today. I had Representative Bratcher. A lot more House members who have been through a redistricting. I actually had the honor of chairing this committee the last time we did redistricting, and it's a pretty stressful process. So get ready. A couple of things that I think would be helpful for people to know. According to federal law, we have to draw the 6 congressional districts to exact no deviation population. And counties can be split with impunity in order to get to that number. So no deviation in those numbers. In the Senate, we can split counties only if the counties have more population than a Senate district. So it looks like the mean Senate district is going to be about 118,000. According to case law, we can go up or down 5%. So in the last redistricting, we were able to split Jefferson, Kenton, and Fayette. It appears based on population trends, we're going to be able to split 5 counties. You can add Warren and Boone to that mix. And that's based on U.S. Census data population estimates from 2019. In the House, I think you can split counties, but it has to be according to certain constitutional and statutory reasons. You can't do it with impunity, but you can obviously, if you look at the current districts that were drawn under the previous party's control of the House, there are some pretty unique lines that you all are familiar with, and those stood up to judicial scrutiny. So just a few Kentucky-specific things that we're going to have to look at, but I think the most important takeaway is hopefully we get these numbers in September and we can start working on the maps, and we're going to need Governor Beshear to call us into a special session in the fourth quarter of 2021. Otherwise, it's going to take up a bunch of time in January when we have budgets to pass and lots of other things to consider. So I appreciate your indulgence, Mr. Chairman.
Very good. Thank you, Senator Thayer. Senator Alvarado has an introduction of a special guest and a question.
Thank you, Mr. Chairman. Just actually an introduction of a guest. For those of you who don't know Mick Bullock, he's in the back of the room here today. So I know we've got Ms. Underhill and Mr. Williams presenting remotely, but Mick is here in our presence today. He's the Director of Public Affairs for NCSL, and if you haven't gotten to know him, I would encourage you to get to know him. He's become a good friend, and I've had the privilege of serving on the Executive Committee for NCSL these past 2-3 years now. We are looking forward to hosting, I think, the Legislative Summit in 2024 in Louisville, so we've managed to be able to land that, so there's going to be a lot of work ahead for us to put our best foot forward as always, and in Kentucky we always do that. I think people come and visit our state and always want to come back, so we're looking forward to hosting things in Louisville in the near future. But again, encourage all of you to, if you haven't tested the waters of NCSL as far as membership, attending the summits, talking to the folks that are in Denver or in D.C., they're here to serve us. People on both sides of the aisle, they're really great resources for work of what other states are doing. If you have legislation that you're considering, it's a shameless plug, Mr. Chairman, but I do it for NCSL. I think they're a great organization, so thank you for your indulgence on that, and thank you, Mick, for being here today.
Very good. Co-Chair Bratcher has a question.
Thank you, Mr. Chair. It's good to see Wendy there. I've been a student of hers for 2 years now, I believe. So she's great, and she's always got great answers when we come up with some goofy questions. And I've got a goofy question now, so this might not be too goofy, but you said that differential privacy is under the courts in Alabama, and if something happens with differential privacy, then it could delay it 3 or 4 more months. Did you say that? And part 2 of that is do you have to have this privacy component in the census numbers? Is that a federal law or something that we have to abide by?
Mr. Chairman and Representative Bratcher, thanks for that question. And I would have said that I was learning under you during these last 2 years. I have a story that you shared with me in Providence that I've used a number of times. So as for the differential privacy, there is a federal law that requires that the respondent's information is kept private. That's been the law of the land for many decades. I want to say 5 or more decades. The way the Census Bureau has approached that privacy question has changed over the course of the decades. They keep looking for a better system. In 2010, they used something called swapping. So if you had a very small census block that only had 3 people in it, you could identify them too easily. So they'd swap the racial and age characteristics of those 3 people to a different block somewhere else in the state. So the state numbers would work out the same, and you'd still see 3 people in that census block. They just wouldn't be, you might say, the same 3 people. So the Census Bureau has been always looking ahead and working on privacy, and they realized that if you used big data, people who are capable of managing major data sets, and you took all of the many reports that the Census Bureau produces, you could overlay them on each other, and you could begin to identify more people in the nation than they felt was in alignment with the federal law. So that's why they said, we got to find something different. And they found this thing called differential privacy, which is, I didn't even know that mathematics was inventing new things, but apparently mathematics is always a growing and developing field, and differential privacy is a new thing out of math. And it may work in many instances in the future. I think we're going to start to hear about it more because data privacy is a major concern, of course, but applying it here has some people's feathers ruffled and concerns about the accuracy, because anything you do to inject noise, which is the official differential privacy term, reduces the accuracy. So instead of swapping 3 for 3, they're going to just make maybe that census block with 3 people in it. Maybe it'll have 15 people in it, and another might end up being a 0. And it all works out at the end at the state population level. But that's not good enough, of course, for a redistrictor. And it's very much a hot question amongst people in the redistricting world, whether what will be provided will be satisfactory for the use case of redistricting. So that's why this lawsuit was filed. The plaintiff said, what you're about to give us is not going to be accurate enough. And I think the mathematicians can have their own opinions. Some go one way, some go another. What I hear from redistrictors around the nation, there are many reports on what the data would look like if it were treated with differential privacy. And I'm happy to share all of that with you. We have a webpage called Differential Privacy Explained. And at the bottom, there's lots of the reports that various states have produced. It seems to me, though, that what matters is the outcome of that case. And whoever is victorious at that level, it's going to get appealed, and it does go straight to the Supreme Court. So I don't want to necessarily say that this is going to be just as much of a mess as what we've already experienced. I think it's possible that there will be some things that we just can't foresee. I just wanted to highlight it as a thing that could cause us future hiccups. I hope that was helpful.
Yes, it was. If you don't mind, Mr. Chair, one more. There was something I read that the census, and I don't know if you can answer this, Wendy, but the census came out with some data, and some states say, like, I think California was going to lose 2 districts instead of 1. They balked at that, and the census revised it and come back out. Can you speak shortly on that, or do you know anything about that? And that's my last question, Mr. Chair.
Thank you, Mr. Chair and Representative. I have not heard that, and I question that. The Census Bureau has put out just one set of data so far, and that is the state population. It is fair to say, though, and I think this is where the confusion would come in, I'm now realizing, over the course of the last several years, various groups, including major data managing type groups, have been putting out estimates of what they think would be the number of losses and gains in the various states. And California was looking like it could lose 2 seats, and New York was looking like it could lose 2 seats, and Texas was looking like it could gain 3. But all of those were estimates based on that American Community Survey, taking the 2010 data and moving forward with it, with the ACS data. So no one ever promised that those estimates were going to be the exact right data. So then when they did come out, they got the results. Some people were surprised. New York lost 1. They were actually not that happy about it because they lost even that one by something like 89 people. And they thought surely the Census Bureau could have turned up 89 more people. But they could have been happy because previously it was believed that they were going to lose 2 seats.
Thank you.
Okay, we have one more quick question. Representative Flood is remote. Representative Flood?
Chairman, thank you so much. Yes, Ms. Underhill, my question is, given that Kentucky's a state that doesn't have, say, a requirement that we have public hearings, and yet I've heard you mention that it's a critical component, or I should say a component that you've put forth, what would be your case for why it would matter for us to do that now? You said this might be a period of time when we could be doing it. What would you say to that?
Mr. Chair, Representative Flood, I will say that generally speaking, just putting all 50 states in a bucket, holding public hearings is common practice. Whether Kentucky needs to do it or not is strictly a decision to be made in Kentucky. In 2000, let's say, apparently, and I wasn't in the business of the census or redistricting at that point, so I'm going on what my boss, Tim Story, who's now our executive director, had said. The public wasn't engaged. This was a thing that people who were politically active did. Then in 2010, there began to be more public interest and more articles written, more presentations given about how the public should engage on redistricting. And throughout 2010 to now, it's been a steady flood. I didn't mean that. I mean, just the word is a normal word there, of calls for public hearings. And so a number of states do have it built in that it is in their constitution or in the guidelines that their committee adopts for doing redistricting. And that could easily mean, like in Wyoming, it means holding something like 6 hearings in 6 parts of the state to hear what people have to say. So it is not required. If it's not required, it might still be something to consider if you feel as though there's a groundswell of interest on the part of the public in how this process takes place, in a way that then you instead of them saying you made those critically important political decisions behind closed doors, you can say we invited in your voices. So strictly up to you all.
Thank you, Chairman, for that question.
Very good. Representative Nemes has a question.
Thank you, Mr. Chairman. I would also note and add to my friend Senator Thayer's comment that there's another set of maps to be drawn, and that is judicial redistricting. The Supreme Court and Court of Appeals in Kentucky, their districts have not been redrawn in over 3 decades. There are 2 districts with over 650,000 people, and there are 2 of the 7, and there are 2 of the 7 that are more than 200,000 people, less than that. So we have to do the appellate districts for the judicial lines as well, and then also, as my friend Representative Johnson has led the effort on this, we have trial court redistricting that needs to happen. I know there's a family judge in Davis County that needs to happen, and we need, and then a few others, one in Representative Smith's area as well. So judicial districting needs to occur. I would note, Leader Thayer, that a lot of people weren't in this room in redistricting last time, but I was the lawyer for the House Republicans when we had the 2012 maps thrown out because they were wildly unconstitutional and stretched everything possible to clinch onto the majority that was then in existence. So the Kentucky Supreme Court knocked that out in an unprecedented, decided an hour after the oral argument. Even those maps were so bad. And so some of us have experience that we're not here as well. On to my point, and I have a question for Ms. Underhill. Community involvement, as Representative Flood said, is very vitally important. I've met with League of Women Voters a few times, and I'm happy that they're making a contribution here. a very good effort. They have released maps that I think are very thoughtful. And so I'm happy that League of Women Voters is involved, and I call on the rest of the community to get involved in this. This is really important. It may not be as interesting as what a lot of policy is, but it may be drier, but it is very, very important. My question, Ms. Underhill, is this. To a lot of us, talking to most members in the majority, racial diversity is extremely important to us, and we believe that we should have in the past had more minority-majority districts. There certainly could have been an additional one in Louisville, and we would like to maximize the minority-majority districts if possible. So if you could comment on that, what exactly does that mean under the law, and are there any best practices to ensure that we have as many minority-majority districts as we can have in Kentucky? Ms. Underhill.
Mr. Chairman and Representative, I would like to ask Ben Williams to address that if he can come on and do that. Ben, are you there?
Yes, I am. Thank you, Wendy. Mr. Chairman, Representative, thank you. This is in my slides in the second half of the presentation, but happy to address this now. The current law states that the Voting Rights Act does require that in particular circumstances that are delineated in a couple of cases that were decided in the 1980s and further elaborated in the 2000s, that if Section 2 of the Voting Rights Act, which protects the rights of racial, ethnic, and lingual minorities to representation in representative bodies, if it applies, a district must be drawn in that particular circumstance. If the Voting Rights Act does not compel the creation of that majority-minority district, then the 14th Amendment of the Constitution, which prohibits racial gerrymandering, would prohibit the creation of any district in which race is the predominant factor. So predominant is a squishy term. The Supreme Court has acknowledged in the past that it's a squishy term. I mean, it just means 50% plus one. This is a qualitative analysis. How do you determine when something is 50% plus one and when it isn't? And that's a judicial fact-finding mission that happens at trial courts. So as long as the Voting Rights Act compels a legislature or commission to draw a district to empower a minority group to be able to elect its candidate of choice, then it should be drawn to avoid legal liability. Which I realize, Representative, is not a direct way of answering your question. And the only reason I say that is because I haven't seen the analysis done in your state of the racially polarized voting analysis under the Thornburg v. Jingles case to see which districts and which areas of the state would require that. I'm sure that you have legislative counsel and potentially a demographer in your state who has looked at this and could tell you based on their preliminary analysis, this is what the areas in the state in which we think districts under the Voting Rights Act may be necessary.
Okay, one summarizing comment from Senator Thayer.
Well, I'm going to summarize, but it might not just be one comment.
Okay, there you go.
I mean, do you know me, Mr. Chairman?
I do.
A couple things. I am obliged to point out that Senator McGarvey, who is participating via Zoom today, wanted me to point out that he was here the last time we did redistricting, and everybody knows my affection, both personal and political, for Leader McGarvey, and I would never want to leave him out in any way whatsoever. Also, I want to endorse what my colleague, Representative Nemes, said. I fully support, once and for all, finally doing judicial redistricting next year. This is something that we've talked about doing. We've seen maps. We've passed bills in one chamber and not the other. It's time. It's time. And there are going to be some massive changes made to that map as well. I also want to point out that the illegal map referenced by Representative Nemes when he was a citizen lawyer, it was the House map that was thrown out, not the Senate map. And I also want to point out that the first Governor Beshear called us into a special session for redistricting after a legal case took place. And it is my hope that we do not require judicial action or a legal case for the second Governor Beshear to call us into a special session. We will know when the time is right and make that request of him. And it is my hope that this Governor Beshear will also call us in to a special session. And I also want to remind, as a follow-up to Representative Nemes's comment, that certainly, just like any bill, and the redistricting maps they're bills. They are legislative bills, or as people like to call them, pieces of legislation, which I don't like. They are bills. And just like every other bill, public comment is warranted and expected. But I want to remind everyone that in Kentucky, the maps are drawn by the General Assembly. We are clearly imbued with the sole discretion to draw legislative maps and the congressional map. And that's the way it's going to be. And we will draw these maps under the statutory and constitutional guidelines that are provided to us. And Mr. Chairman, that's all I have to say about that.
Very good. Thank you, Senator Thayer. And I will mention that judicial redistricting is on our planning for interim, so we'll have a chance to visit that hopefully during an interim meeting. So with that, we'll move on to the second part of our meeting today. Mr. Williams with NCSL will talk about redistricting, and we'll have questions after that. Mr. Williams?
Thank you, Mr. Chairman, members of the committee, for having me here. It's always a pleasure to testify in the States in front of our members, but Kentucky has special resonance for me because I have family in Ashland. I grew up right across the river in Huntington, West Virginia. So this is like coming home to me virtually. So I'm happy to be here, and thank you for having me. So I'm just going to run through these principles fairly quickly of the law and criteria. Senator Thayer did an excellent job of summarizing a lot of this. So for the sake of time, I'm going to breeze through this fairly quickly so that I can save as much time at the end for questions as possible. So as I was mentioning earlier, racial gerrymandering is one of the key doctrines of federal law that regulates redistricting. It emerges from the 14th Amendment to the U.S. Constitution under the Equal Protection Clause. The claim has evolved over time. In the 1990s, these cases, which came primarily out of the South, they were white plaintiffs suing for lack of compliance with traditional redistricting principles. In the 2000s, the cases sort of died away because of a case called Easley v. Cromartie. But they reemerged in the 2010s with different plaintiffs this time and different legal sides. And in this case, it was Black plaintiffs suing on vote dilution claims that were outside the scope of the Voting Rights Act. So the Voting Rights Act compels districts to be drawn in certain circumstances, but it doesn't compel districts to not be drawn in certain circumstances, which some theorists claim is a form of vote dilution, in which case racial gerrymandering serves that function currently. I will note that racial gerrymandering doctrine has changed every single decade it has been in existence, so there's no reason to expect that it would stay exactly the same this decade either. But as of this moment, this is the law around racial gerrymandering. And this is a brief breakdown of the legal theory behind how racial gerrymandering works. I believe this was submitted to all of you for review, so I won't go over this in detail, but just know that if you asked your counsel about this, they would say that this is a slight oversimplification of the legal reasoning that courts go through when they're looking at a racial gerrymandering case, but it is a good way of envisioning what sorts of steps a judge will be looking at, even if it doesn't include stuff like the evidence that is used. So the second area is partisan gerrymandering cases. I believe you all are eminently familiar with these. There were many, many cases in federal courts in the 2010s that were arguing that districts were unconstitutional partisan gerrymanders, either under the First or the 14th Amendment. In 2019, those cases were deemed no longer judiciable in federal courts, so we will no longer be seeing partisan gerrymandering cases in the federal judiciary, but the theories from those cases have been successfully used in state courts. And so these claims, while they're dead in one venue, may not be dead in all venues. The other principle is one person, one vote. And as Senator Thayer was mentioning, you have the different types of deviation for congressional districts. It's exact numerical equality. For state legislative districts, it's a 10% overall deviation. I have it listed as plus or minus 5 here, but in theory, under federal law, you could have a deviation for state legislative districts that is +3 to -7. Now, in your case in Kentucky, there could be state laws that change that calculation, but for the states that do not have your specific rules, that is the governing federal law of the land. The other main principle is Section 2 of the Voting Rights Act. This prohibits vote dilution nationwide. I was mentioning it earlier. The burden of proof is discriminatory effect, not discriminatory intent. Typically, you can imagine it would be somewhat difficult to prove discriminatory intent in something like redistricting, but that is not a burden that plaintiffs have to overcome to succeed in one of these cases. So, as I was mentioning earlier, when does Section 2 of the Voting Rights Act apply? And we have a case from 1986 called Thornburg v. Jingles that gives us these three preconditions. First, the minority group needs to be sufficiently large and geographically compact to constitute a numerical majority in a particular area. Second, the minority group needs to be politically cohesive. So one area where this comes up sometimes is in South Florida, where you have different Latino groups that vote differently. They may have a sufficiently large and geographically compact population to constitute a majority, but they may not be politically cohesive because you have some voting for Democrats and some voting for Republicans. But if they are politically cohesive, then the last step is to show that white voters act as a bloc to defeat the minority group's candidate of choice. Those last two principles are known as racial polarization. If the Jingles preconditions are all satisfied, then the courts move on to the analysis of the Senate factors, which are listed on the screen. The Senate factors are named such because they come from the U.S. Senate committee report that was the 1982 reauthorization of the Voting Rights Act as factors that the senators wanted courts to look at for when Section 2 should apply. In general, it's a totality of the circumstances analysis. You don't have to satisfy all of these. It's just some, and it's a judicial decision making. But in general, if a plaintiff has satisfied the Jingles preconditions, they probably are able to satisfy the Senate factors as well. The other section of the Voting Rights Act that is most commonly cited is Section 5, which was known as the pre-clearance regime, where states would have to receive approval from a federal court in Washington, D.C., or the Department of Justice to change any of their voting laws, which included redistricting plans. And in 2013, in a case called Shelby County versus Holder, the formula which determined the jurisdictions which were covered by Section 5 was struck down for being an unconstitutional violation of the principles of federalism because it had not been changed at all since 1965 when the Voting Rights Act was initially enacted. So as of today, Section 5 and the pre-clearance regime is still the law of the land, and it applies to exactly 0 jurisdictions. So for all intents and purposes, it is no longer valid law. However, in theory, Congress could reenact Section 4 of the Voting Rights Act, which was the coverage formula, and re-subject certain states to the pre-clearance regime. And there are bills currently in the US Congress that would do that, although their prospects are do not seem very good, but it is something I wanted to flag for you so that you could be aware of if you weren't already. Principle of state law. If you remember, I mentioned a couple minutes ago that the partisan gerrymandering cases were not necessarily dead. And that's because there are these new legal claims called free and equal election cases. So a lot of state constitutions have these provisions, 30 states do, and they essentially say that elections need to be some combination of free, equal, and fair. For decades in most states, these claims, these provisions just sat dormant. They didn't really mean anything. They weren't frequently used in cases. But in 2018, the Pennsylvania Supreme Court, which had a clause that said all elections shall be free and equal, very similar to Kentucky's provision. The Pennsylvania Supreme Court said that that provision had within it a prohibition on excessive partisanship in redistricting, and it struck down the state's entire congressional redistricting plan for being an unconstitutional partisan gerrymander under state law. And this is important because there is a doctrine at the US Supreme Court called the Adequate and Independent State Grounds Doctrine. And what it means is that if there are adequate and independent state grounds for interpreting a state's own constitution, and there is no federal analog that is at play. So, for example, Kentucky, I'm sure, has a freedom of speech and a freedom of association principle in state law. There are analogs in federal law as well. Absent such an analog, the US Supreme Court will not intervene because the US Supreme Court considers it to be outside of its jurisdiction to interpret what state law should be. That is left to the states under our federal system. So, as a result, the US Supreme Court did not intervene in the Pennsylvania case. And later that year, a North Carolina case was filed under the same principle of North Carolina law, same legal arguments. And again, in North Carolina, a panel of judges struck down that state's entire congressional redistricting plan for violating their state's free elections clause. That was not appealed up to the North Carolina Supreme Court, and it never made it to the US Supreme Court. But up until 2018, this was not a doctrine in redistricting that existed. Going into 2021, there are 2 states that have interpreted this, and there are 30 state constitutions that could have claims similar to the ones that occurred in Pennsylvania and North Carolina. I don't flag this for you to say that this is necessarily how all 30 states are going to decide this issue if a case comes before them. Obviously, if you're having 30 different state interpretations of 30 different state constitutional provisions, you could reach 30 different outcomes. But I am flagging it because this is one area that we at NCSL expect to see significantly more litigation in this decade. And it is the one big new area of law that has emerged. I was also asked by counsel to touch on a couple of Kentucky specific cases for you. I know that this came up in earlier conversation about the splitting of counties in Kentucky. So I won't go into significant detail about this, but in general, the Kentucky Supreme Court has interpreted Section 33 of your state constitution, which has dual mandates that districts be nearly equal in population without dividing any county. There was a case in 1907 that's put more emphasis on the equal population end of this clause. Recently, we have shifted back through these 2 cases, Fisher v. State Board of Elections and Legislative Research Commission v. Fisher, to emphasize that the splitting of counties and legislative redistricting must be minimized within the plus or minus 5% range for deviation. So in Kentucky, under these 2 cases, you can't do the +3 -7, have a 10 overall range. You have to have no more than +5 or -5 from the ideal district population. In terms of principles now, shifting to principles or criteria, as I prefer to call them, the only federal criteria for congressional districts is that they be single member. Other than that, it's entirely up to the states what to do. One of the more common principles is compactness. It's a common traditional redistricting principle. There are a myriad of ways to measure it. I believe there are over 40 peer-reviewed methods of calculating compactness at this point. 2 of the most common ones are REOC and Polsby-Popper. I've given the formulas on the left-hand side of the screen. And the image on the right-hand side of the screen, I've included just to show you that these are the 2 most popular compactness measures. And in that burnt yellow rectangular district, Polsby-Popper gives it a score of 0.589 on a scale of 0 to 1. And REOC gives it a score of 0.382 on a scale of 0 to 1, with 0 being least compact and 1 being most compact. So it just goes to show you that the particular compactness metric that's being used at a particular time can have a significant outcome on determining whether or not a district is itself compact. And both of these should be available in your state's redistricting software, along with a couple of the other more common methods of measuring this. Another principle is contiguity. It occurs in all 50 states for at least legislative or congressional districts. And the rule is you must be able to go to every part of the district without leaving it. The only times where this really arises as an issue is when you have non-contiguous locality boundaries. So if you had a jurisdiction that had annexed neighborhoods that were not contiguous with the rest of a particular city, then that might be an area where that could be a problem if you wanted to keep city boundaries whole and county boundaries whole. Maybe you have to split one or the other. And it also arises with water. So this is, as you know, the Kentucky Bend and far southwest Kentucky, where you have one part of your state that is wholly cut off and borders only Tennessee by land and Missouri by water. And this is just another example of this occurs frequently in states where water is an issue. So in Kentucky, I would imagine that you would just combine this with the adjacent part, but that's just a way to highlight that this can become an issue in certain cases. State principles, preserving political subdivisions. I don't really need to go into this because you have a quite strict whole county provision in Kentucky, but just know that this is a common traditional principle, and not in Kentucky's case, but in some states, they have discretion to choose what type of political subdivision they are trying to preserve: city board, school, county, etc. Another common principle is preserving communities of interest. It's codified in 25 states. It's frequently used in others unofficially. There's no agreed upon definition. I've included 3 examples for you. Alaska and Missouri both have a positive definition, which is to say what a community of interest is. California has a negative definition, which is to say they define what a community of interest is not, and then leave it up to their commission to determine what communities of interest they will protect in redistricting. Another principle is preserving cores of prior districts. This is somewhat infrequent, and it's usually just permitted but not required. And the rationale typically given is that you don't want to unnecessarily break up people's relationships with their representatives. I've given you an example of your neighbor, West Virginia, on the left-hand side. As you can see with the red circle between the 2000 map and the 2010 map, the West Virginia legislature moved one county from one district to another. And that was their entirety of their congressional redistricting. They did their hands and said, okay, we're done. We moved one county from one to the other. They're pretty close to equal population. We'll call it a day. Some states specifically reject this. The Arizona Constitution actually requires that they start anew every single decade. So there's no guarantee that the districts will look anything alike from cycle to cycle. And then lastly, there are a few emerging principles that are becoming more common. Typically, these are related to something about partisanship or the political performance of particular districts. So 17 states have a prohibition on favoring or disfavoring an incumbent candidate or party. That's a sort of a catch-all. The exact wording among those 17 does vary significantly, and it really depends on the wording, what is included and what is excluded from the prohibition. There are 5 states that have a prohibition on using partisan data. Most of them give an exception for compliance with the Voting Rights Act, because if you remember back, the requirement that you figure out whether or not there's political polarization among different racial groups, obviously you would need election results to make that calculation. So in all other circumstances, the states prohibit the use of partisan data, which would be could be defined as many things, but most commonly it's defined as election returns, party registration information, the residence of incumbents, the residence of potential challengers, among other things. There are 5 states now that require their districts to be competitive. Competitiveness, again, no agreed upon definition. This is a theme among redistricting. There's no agreed upon definition to anything. The 2 most common definitions of competitiveness are that districts either should be as close to 50-50 across all districts as possible. So if you had a state where the political makeup and the elections that are used to calculate the competitiveness formula are 55 for one party and 45 for another, then all of the districts should be drawn as closely as possible to be 55% for one party and 45% for another. Another definition of competitiveness that is used is that the maximum number of districts should be drawn as close to 50-50 as possible, and then whatever happens to the rest happens to the rest. That is the definition that's used in Arizona, and Arizona has had some very swingy congressional districts as a result over this decade, because there are 2 or 3 districts that were drawn to be as closely divided between the parties as possible. The last principle is proportionality. You are one of the, I think you're the only state that borders both of the states this cycle that will be using proportionality. Those are Missouri and Ohio. And proportionality is similar to that first definition of competitiveness that I used. It says that in general, the legislature should reflect the overall makeup of a particular state. So looking at the statewide election results that are selected by the legislature, or the commissions in the case of Missouri and Ohio, the district should be drawn to reflect the political makeup of the state. So let's say Ohio, if you looked at the elections that are chosen, is 53 Republican, 47 Democrat. You would try to draw a 100-member legislative body to have 53 Republicans and 47 Democrats, just to give you an idea. With that, there are final thoughts about what your committee can be doing now. I know Wendy's already touched on this a little bit, so I'm not going to go into significant detail on it, but the last thing I want to mention is that we do have some resources for you that may be helpful. The one in the middle is our Redistricting Law 2020 book. I think I've got mine up here. Mine's a little beat up. Yours will look way better when it comes in the mail, I promise. And this is an excellent resource that if members of the committee don't have, I strongly encourage you to reach out to us, and we'll make sure to get one shipped out to you. It's free for all legislators and legislative staff. And we also have a Redistricting Seminar coming up. This is our final one in July. Kentucky has been well represented at several of the previous ones, and I was looking at the registration, and I see that some folks are coming to Salt Lake City as well. So we're looking forward to having you. And with that, Mr. Chairman, I will turn it over to you for any questions, and thanks for having us.
Thank you, Mr. Williams. We have a few questions. First, we have Representative Wheatley.
Thank you, Mr. Chair, and thank you to the NCLS for this presentation. As a newer member of the Kentucky General Assembly, I can tell you that my experience with NCLS has been nothing but fantastic and great resource, and this has been very enlightening, as some of the webinars that we have attended have been very helpful too. I just have a couple questions, and they're really related, so hopefully we can get through this pretty quickly. This would be for Ben, for Mr. Williams. You just talked about the emergent principles. Can you talk a little bit about how those principles have emerged, whether they have emerged from basically just state law changes? Did the state law changes come as a result of court cases, or did it come as a result of commissions, advisory councils? Why are these or how are these principles emerging?
Absolutely, Mr. Chairman, Representative. They have emerged through changes in state code or state constitutions. Some of them have been included as part of shifts to commission systems. For example, Colorado, the state that I'm based in, the legislature sent a couple of commission bills to the voters in 2018, and we shifted to a commission system here. And those bills, they included all the structure for how the commissions work, but they also included new criteria as well, which included one of these prohibitions on favoring or disfavoring. And so that is one area in which they do emerge. Some of them are quite old, though. Nebraska has had this prohibition for decades and is used on occasion. So it varies in how they emerge, but we call them emerging just because if you looked back through the annals of American history, you wouldn't see these until post the Baker versus Carr 1960s redistricting cases. They tend to emerge from 1970 and beyond.
Okay, thank you very much for that. And if I can just one more quick question. Ms. Underhill, she shared with us lawsuits that have occurred already this cycle, and I'm wondering if there have been any lawsuits, even preemptive lawsuits or declarations sought related to the emerging free and equal clause in state constitutions, to get that concept already established as the legislature's redraw districts. So have there been any cases like that you're aware of?
Mr. Chairman, Representative Wheatley, I am not aware of any such cases. I can imagine there might be standing issues with proving the injury if the districts haven't been drawn yet. But we will see as these progress. I think that if you look through the litigation that has been tracked through the 2000s and 2010s, redistricting is a particularly litigious area of state law, probably could be the most litigious area of state law relative to the number of bills passed per decade. And so it is entirely possible that there will be multiple cases filed this decade in various states, but it's so new. I mean, only 2 cases in the past 3 years, and those were the first 2. I really mentioned it just to highlight that this is an emerging area that there's a lot of uncertainty about still. And so we'll have to see where this pops up in the years to come. Hopefully, if I'm fortunate enough to be testifying before you again in a few years, I'll have more clear information to share.
Well, thank you for that. And yes, I think this is going to be a free and equal race to the courts if there are too far movement in directions that don't appear to be free and equal. Thank you. Thank you for the presentation.
Representative Nemes has a question.
Thank you, Mr. Chairman. I'll be quick. There are at least two counties in Kentucky that meet at a point. When we draw a map, sometimes they meet at points. And I think at least one of these couplets, if you will, are going to be implicated in redistricting. So what does federal law say, if anything, about point contiguity?
Thank you, Mr. Chairman. Representative Nemes, good to see you again. The point contiguity, there's not a lot in federal law about it because there's no federal requirement that districts be contiguous. The only requirement of the federal government is that districts be single members. So it's entirely up to your state's interpretation. And there are some states that state courts that have held that point contiguity is not permissible, but I'm not familiar with the Kentucky law. I would refer you to legislative counsel on that, who I'm sure would have an answer if the Kentucky Supreme Court has weighed in on this in the past. But in general, if it is not expressly prohibited under your state law or state courts have not prohibited it, then it is permissible.
Thank you. Any other questions for our presenters today? If not, I have a couple of announcements just to make you aware of before we adjourn. On the website, there is a letter from the League of Women Voters that's been posted in case you want to take a look at that. Representative Nemes mentioned that earlier about their concerns, and they are made available for you. Secondly, in the packet, Ms. Underhill and Mr. Williams' information is in this packet. If you have further questions, you can email them, and as they stated earlier, they're at your disposal to be of service. And then finally, we have 5 for all the new folks on the committee, which there are several. We have 5 ladies and gentlemen that are helping us in our committee, LRC employees, and I just want to have them raise their hands real quick so you know who they are. Alicia Miller here is their CSA. Angela Rhodes, she's out of the room. Miss Peggy Scaler.
Chantarelli.
Okay, this is Peggy, and and then back here in the back of the room, Daniel Carter and Michael Callan. They are all here to be of service to you during session and during the interim. So if there are not any other questions, we'll stand adjourned. Our next meeting will be July the 20th. We all know Peggy is Peggy. I looked down at your name. I was like, oh.
Good job, Robbie.
Yeah, thank you.
Good job.
Thank you.